Good morning, Your Honor. I'm here on two cases that have been appointed this morning. The first is Miss Michelle McKnight.
Okay.
I think we have to address bond conditions.
Okay.
I think there was a MOA. This is the one we talked about.
Yes, and Your Honor, I do have to correct something I said there in the Westy statement. This is me going quickly. I mentioned to the court that on the terroristic threats and the interference with emergency assistance as well as the criminal mischief, that was the same complainant. It is not. They have the same last name. They both live at that same residence. So it is two different complainants. Both were present at the same residence that all of these incidents occurred at.
Right.
From I can read into it, the terroristic threat complainant was a some sort of relative to the criminal mischief and interference complainants, either a mother or something like that.
All right, pause right here. This is where things quietly get messy. Multiple complainants, same address, same last name, but not the same person. That matters legally. Bond conditions depend heavily on who is protected from whom, and confusion here can lead to serious due process issues. Question for you. If even the court sounds unsure, should bond restrictions move forward this fast?
Still fighting with everybody at the house, right? And then
Right.
do we even know if they won or back?
There's no rip call done on it at all. I think
like-
is there two MOAPs in place? Like, I'm confused because I was told that there's like a MOAP issue, but if there's two MOAPs that are being issued on two different complaining witnesses, or if there's just no returning to the
I
house.
haven't gotten that deep yet,
Okay.
so I don't know.
Okay. And then also she has that on the terroristic threat, I believe. She has no.
Right, we need to, so there
Yes.
is a
She's
bond.
GOB eligible though, I think. Yeah.
I'm gonna give her one,
Okay, great. Thank
So-
you very much, Your Honor.
but
And here's the shift: family chaos to constitutional law. We're now entering probable cause territory, and this is where arrests either stand or start to crumble. Watch closely, because everything that follows depends on whether the stop itself was lawful.
I'm gonna order not to go back until we know that they.
That's fine. That's fine.
No.
She's staying at her dad's house, so for now.
And then,
so that's fine.
And then just, where is she? Is she here?
Yeah, she's. On the live stream off, please, for her approach. Thank you.
Good morning, sir. How you doing?
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. Officers were dispatched to a Holiday Inn in Harris County, Texas, in response to a disturbance. The caller reported that two white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed a Mitsubishi, which matched the description given in the parking lot, headed toward the nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. Officer asked the defendant if he was involved in a physical disturbance.
On paper, this looks strong: HGN clues, odor of alcohol, breath results above the legal limit. But here's the twist most people miss. Probable cause doesn't start with intoxication, it starts with the stop. If the stop is weak, everything after it is at risk. Do you think these facts justify pulling him over in the first place?
And the defendant stated yes, that him and another individual got into a physical fight and that he got into his car to separate himself and calm down. The defendant stated he was headed toward a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 0 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were a .103.
This is a textbook argument, and honestly, a powerful one. Anonymous tip, vague description, no observed traffic violation. Courts have ruled before. You can't stop someone just because a caller says so. This is the judge signaling, I'm not convinced. Should officers need more before flipping on those lights?
And a .113.
Judge, I'm going to say no probable cause here because
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing. You know?
and And probable cause doesn't exist. He's 0 for 6 on the walk and turn, 0 and 6 on the one leg stand. There is no law in Texas that a person cannot drink. Just because he smelled alcohol does not mean the person is intoxicated.
Do we have anything that he's doing, you know? Tell me what led them to him.
Yes, sir. So what led to the investigation was a caller who reported the disturbance. The officer arrived and he observed a car which matched the description that the
So
caller
that would be
gave.
like me calling and saying, hey, this guy did this over there. The cops go, no. I mean, theoretically, would be anyone could make a phone call, make an allegation, cops go, boom, and just stop, do whatever they want without, no probable cause.
Thank you, Judge.
Be careful, man. There's a lot of haters out there. Don't let them get you, you know? Life's too short, all right? All right, good luck. So, Mr. Cummings, I'm not going to make a decision. I'm going to let both lawyers brief.
This moment is fascinating. The judge isn't just acting as an umpire, he's stepping into a mentor role. That warning about volatile relationships? That's experience talking. It's also a reminder, even without a conviction, your behavior outside court can land you right back inside. Ever notice how some judges lecture harder than they sentence?
Brief the case so we can get more of an understanding as far as law.
Yes, sir.
As applied to your case,
Yes,
to
sir.
make a good determination whether there's enough probable cause to go forward.
Yes, sir.
In the interim, don't have any weapons. If I find that you are with a weapon, if I find that you become a danger, I will revoke your bond and put you in jail.
Yes, sir.
I'm not asking for much.
Yes, sir.
You know, there's a lot of relationships that are volatile relationships, meaning ones that you're constantly banging heads.
Yes,
This
sir.
is one of those. Be careful because you could be on the losing end of that. There's a
Yes, sir.
lot of vindictive people out in this life, you know?
Yes, sir.
Put yourself with good people, none of that happens, you know?
Yes, sir. I understand.
I'm okay with you going back, but just don't have any threatening or harassing
Yes, sir.
contact with this person. I don't care what you think is threatening or harassing, it's what she perceives. So
Yes, sir.
is this threatening and harassing? It is, and it can land you in jail.
Yes, sir.
Conduct alone can violate. You understand?
I understand.
Okay. I'm gonna have them create the bond conditions, we'll have you sign it, and then I'll have you'll be free to go. Just stay in touch with her and she'll tell you what happens next week. Okay?
Thank you, Your Honor.
Thank
Don't
you.
leave yet. We need you to sign conditions and then you can. So no weapons, no threatening. Right?
Your Honor, if he goes down, can he go down and put money in the meter and come back up?
Yeah, just make sure you come back to sign the conditions.
Okay.
If you don't, I will issue a warrant.
I'll be right back.
Okay, take your time. All right, good morning, Mr. Greathouse. Looks like you have worked out an agreement where they're offering you time served on DWI. You need to understand that this is going to go on your record. It will be there for the rest of your life. Do you have a CDL? This is going to suspend the CDL. You know, and like we've talked about earlier, when you have a CDL, you're held at a higher standard to everyone else in this world. Because of that, you drive bigger machines, more dangerous, heavier weight. So if you get into an accident, it's so much worse. So the other thing that you need to understand, you pick up another
One mistake can end a career forever.
CDL for life. A second DWI conviction is a lifetime suspension of that CDL. You understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. There's no turning back. You can never, it'll go on your record. It'll be there forever. Is this what you want to do? So, how do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow the agreement. It's 3 days in jail. Credit for the 2 days that you've done. You know, the idea is that we all make mistakes, right? But the idea is that you don't continue to make mistakes that you endanger other people's lives. That's why we have greater sentences. That's why we have prisons. That's why we have jails, because some people just don't get it. Do you have to go to prison to learn? You know, it's a rhetorical question. It's not, but you don't have to answer. I'm just telling you, that's why we have enhanced punishments, why we do longer jail sentences, because some people just don't get it. I mean, really, if you want to get lit, great. Take an Uber, $40, $50 it could have cost you. One button. I hope that you use it in the future. I also have to suspend your license. I'm going to do it for 90 days. That is the minimum.
Thank you, Judge.
Just be careful, man. It's not hard, right? Just, you know, if you're going to go out and get lit, if you do it, just really. How do you think? Did you say guilty?
You did, Judge.
All right, I'm going to find you guilty. I'm going to follow the agreement. The other thing is this, the reason I'm telling you about the mistake is because your lawyer is asking me to waive the fee for you. Is this above a 0.15 or no?
I'll go with you.
No, it's not. Let me see. This is a $3,000 surcharge that you would normally be paying on top of this. All the other stuff that you're doing now. I'm going to waive it for you now.
Thank you, Judge.
But if you come back with another DWI, it is a $6,000 surcharge that taxed onto you. Do you understand?
Sir.
All right. Good luck to you.
And Judge, I'll just submit to the court. He has taken this seriously. He's done a lot. I think he's made the start of a good recovery. So I just would submit.
That's great. But the problem is that time heals all wounds. It's fresh in you now. What's going to happen in 20 years? Are you still going to remember this in 20 years when you go out on a date and you're just, that's the rub. Are you going to remember this in 20 years? Are you going to remember this in 30 years when there's a death in the family, something that you can't overcome and you go out and you just get blitzed? That's the true thing. That's what it's about,
Sure.
Good luck. And for what it's worth, you're doing great. Just keep it on.
I'm going to remember you. You're like that father that I never had. That was my butt every time I came in here.
And that's what we do, like I've got 4 great kids at home and then I've got another 2,000 kids here. Some grow up and do great. Some kids, I got to sit there and freaking,
Thank you so much.
just,
Thank you, Judge. Maybe excuse me.
thanks.
It's a great opportunity.
So who is Piedra? That's this gentleman. All right. Good morning, Mr. Piedra. You were charged with 2 cases. You were charged with driving while intoxicated. You were also charged with failure to stop and give information.
And this is the other extreme. A .244 breath result isn't borderline, it's dangerous. Combine that with fleeing an accident and prior open cases, and suddenly bond isn't about fairness. It's about public safety and flight risk. Big question here. Where should courts draw the line between rehabilitation and protection?
On the DWI, you're facing up to a year in jail and or a $4,000 fine. On your failure to stop and give information, you're facing up to 180 days and or a $2,000 fine. You are currently being held at no bond. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay?
Thank you, Your Honor. Law enforcement officers observed the defendant driving over a median in the road. Law enforcement officers observed the complaining witness Kirkland and witness Taylor screaming at the defendant to stop his vehicle. The law enforcement officers removed the defendant from the vehicle and they observed the defendant to have strong odor of alcoholic beverage, swaying, and red glossy eyes. The complaining witness stated that the defendant struck her vehicle, that he got out, looked at his hood, but never exchanged information. The defendant then got back in the car and drove off. The damage was approximately $300. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, and the walk and turn and one leg stand were unable to be performed due to an old foot injury. The DIC was read and breath was collected.
Go a little bit slower, folks. She's translating.
Yes, Your Honor. Yes, Your Honor. The DIC was read and the breath was collected. The test results were a .244 and a .234.
You said that he took off from the accident, right?
Yes,
Did
Your
I
Honor.
miss that? How far did he go until they caught up with him?
See all the downs.
He has an open terroristic threat. Threat's open, right? Piedra, page 57.
Judge, it just says that the complaining witness and the witness followed the vehicle until he made a complete stop.
And then the cops arrive at that location.
Yes, Your Honor, and that's when they got out of the vehicle and began screaming to get the defendant out of their vehicle to pull over.
I think he has an open terroristic threat from 2001.
2020,
From 2021, he has an open
yes,
terroristic
Judge.
threat. Am I
Yes,
right?
Judge.
Right? Am I right?
And he tells me that he was deported. And that's why he did not come back to court.
He's in jail on those, Judge. I don't know why he's showing.
Why does it show inactive?
I'm not sure why.
But it is an open case.
No, well, he got picked up. He's gonna be picked up on a case. He's here. He got picked up on terroristic threats.
I
417.
So it is open.
Last Thursday, he got picked up on that warrant from 2023.
Wow. Okay. I find, Mr. Piedra, that you are a flight risk. I don't know that you got deported. All I know is that you have an open case from 2021, and the only reason that we have you now is because you picked up these two other cases. So I'm not going to give you a PR bond. I'm going to set you bonds on both of your cases, but I'm going to tell you now that you are not allowed to drive. I don't know if you're going to bond out, but if you do, you will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's a possible punishment of up to 180 days in jail and a $500 fine. Do you understand? You were ordered not to consume alcohol, illegal drugs, and I'm going to put a guardian interlock on you. If you get out, you must obtain a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. No alcohol, no drugs, random testing, no driving. Guardian interlock. We have given you a lawyer, Mr. Piedra. It is your responsibility to stay in touch with her. If you do bond out, you must stay in touch with her. If you fail to do this again, and if you fail to come back to court, then I will make your bonds high. So I'm going to set both bonds at $5,003. And then the terroristic threat is right now set at 1501. I'll just leave it as is. And then I don't know if he's going to bond out or not, but if he does, then he will be required to comply with the bond conditions. I want you to understand, Mr. Piedra, that I'm going to do everything in my power to protect my community at all costs. I just don't want another death on the roads. That's all I'm asking. Okay. And then this gentleman is...
And this is Mr. Portillo Lopez. And he does have an immigration hold, Judge,
Yes, Mr. Portillo.
as well.
Is it under remote? Yeah, there it is. Okay, Mr. Lopez, you were charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. As part of your bond conditions, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you do not have a Texas driver license and liability insurance, then you are not allowed to drive as well. I guess, will do whatever you want to do with Mr. Lopez. Right now, he's got the immigration detainer, so I don't know if he's going to be able to bond out. So I guess we'll just give you a week or two setting, and then just let us know what you would like to do.
Yes, Judge.
Okay.
I don't know if I don't think he's had probable cause, Judge. I don't see it.
He has.
Oh, yes, okay, Judge.
I'm showing that. Let me see.
All right.
Yeah, they found a problem
Okay.
Yeah.
April 20th. So last night at 4:54 in the morning.
Okay, thank you.
Okay, thanks.